So today we have a very interesting panel, and I'd like to introduce the members of the panel. I'm the moderator. My name is Mihail Galper, and I'm the head of the International Law of the Justice Ministry. And I'm also assistant professor of the Higher School of Economics, and I'm involved in international law, civil procedure, and enforcement procedure. And the composition of our panel is as follows. There are people from the judges community, international organizations, court marshals, and Minister of Justice. So there are execution authorities, jurisdiction authorities, and Minister of Justice. That's the head of the field. So we are going to have a very interesting discussion, I hope. And we have a very flexible procedure and mechanism of discussion. So if you have any questions after any presentation, you can intervene or put your question to the speakers or have a commentary. Well, you can be given floor at any moment you like. So the first presenter, since it is the international legal aspects of enforcement procedure, the floor is given to Marta Pergeles, who is the first secretary of the Hague Conference on International Private Law. The Hague Conference is an organization of very high prestige and authority because they are involved in regulating jurisdiction and international recognition and execution of court decisions. So, Marta, you have the floor, please.
Bonjour. Hello, good morning to everyone. I will continue my very short presentation in English because I would like to, of course, leave sufficient time for my distinguished co-panelists to present other aspects of this very interesting topic. As a word of presentation on the Hague Conference, indeed, as most of you will know, the Hague Conference is an organization, intergovernmental organization based in The Hague, the Netherlands, which is, I think I can say, pioneer in developing mechanisms of cooperation, both at the judicial level and administrative level, because for almost 120 years, that is what the Hague Conference has been doing. And of course, with the globalization of our world, the importance of our work and of our conventions has only increased. Today, I will kick off our panel with some notes on how our work, the work of the Hague Conference, is relevant to the enforcement of judicial decisions in a cross-border context. And I think it is important to say that what we can do is help the citizens, help the companies whenever they have the situation where they have to enforce an act or a judicial decision across the borders. Because as a practitioner was telling me the other day, it is nice to have a judgment, but a judgment is not something you want to hang on the wall as if it were a law degree. It is something you want to enforce, you want to make something concrete out of it. And it is also very unfortunate and very frustrating, I think, as a practitioner, to have to tell your client that because there is no system in place that can guarantee the exportability, the enforceability of that decision, that that's the end of the story, that he has a successful judgment, but that nothing can happen with it. So from that context, I think I should highlight very briefly some of the instruments that the Hague Conference has been developing, and I hope later on we will have a little bit of time to, in discussion, come back to them. I have identified, I think, 3 focal points on our work when it comes to this area of the law. In the first place, I think some of our conventions have created procedures available to foreign litigants to litigate on equal footing with local litigants. You see that, unlike some of the other presentations, I am taking a step forward, and I'm situating myself at the time that the procedure is still taking place. I think other speakers will, of course, speak more about what happens in the country of enforcement. But just to give you a little bit the context of how a judgment somehow originates and how the Hague Conference has contributed to make that procedure as equal as possible. We have the 1980 Access to Justice Convention, because that's where it all starts. I mean, if we cannot guarantee on an equal footing foreign litigants to have access to the courts, then it is a problem. And so it is important, for example, to ban any kind of caution, cautio in Latin, that would make that access to foreign courts more difficult. So that's, I think, one important convention to consider. Taking it a step further, and instruments that are familiar to in particular the huissier de justice, gerechtsdeurwaarders. The Hague Conference has developed instruments that I think are very important in your daily work. I'm thinking here about the 1965 Service Convention. I'm thinking about the 1970 Evidence Convention. Those are instruments that, in the context of the procedure, will facilitate some aspects, and in particular how to export, how to make those documents circulate across borders, and the Evidence Convention, how to obtain evidence abroad. So, of course, it is important to attract as many contracting states to that group of countries, and also to make sure that those conventions operate properly in as many jurisdictions as possible. And so our work does not stop at the level of developing those instruments, developing those cooperation devices, but also in practice make sure that as many countries as possible apply those conventions according to the internationally developed standards. Last but not least, I would like to concentrate on our work in the area of international litigation per se, and talk to you about a convention on which we have also very high expectations, and that is the 2005 Choice of Court Convention. So it is a convention that guarantees something quite fundamental, I think, to our businesses operating on a worldwide scale. That is that whenever in their contract they decide where that litigation will take place, whenever in a contract they identify the relevant court that will hear any dispute arising out of that contract, that decision, party autonomy, so it is finally the decision of the parties to litigate in that place, that decision is recognized and enforced everywhere. And most importantly, and this is also something I think that will be linked to further presentations, that judgment that is rendered in jurisdiction A can be enforced on the basis of that convention in all the other contracting states. So the question here is, okay, and what is the status of this convention? And there I have to say that although lots of work is progressing in many parts of the world, the 2005 Choice of Court Convention has not entered into force yet. But that we are almost there. We are almost there because the European Union is signed and will ratify the convention soon, because the United States signed in 2009 and is really working on the implementation level to be able to ratify the convention soon, and because we also had good news from Russia recently at our annual council, where Russia let us know that the study of this convention is also progressing in this country. So you see lots of very hopeful signals that it is just a matter of time before also this convention helps our businesses create the necessary legal foreseeability in their international transactions. And finally, if I may, this is not the end of our work in the area of international litigation, because, of course, in a contractual context, I think most cases can be solved by foreseeing the venue, by determining beforehand in the contract where the dispute will be litigated. But there are torts, there are non-contractual situations, there are cases relating to inheritance. So there are many other areas where, again, the judgment shouldn't be hung on the wall. It should be enforced somehow in another jurisdiction. So our work continues, and one important element, piece of information that I would like to share with you is that only last month, in April 2012, our council, that is the group of 72 countries that these days are member of the Hague Conference, they gave us the green light to continue with a project that had been dormant for some years. This is the so-called Judgments Project, which hopefully will one day create what I think is a very valid aspiration for the international litigation community, and that is having an instrument that will recognize, that will make it in a broader scope, civil and commercial matters, will make it possible to recognize and enforce judgments. Thank you very much.
Спасибо большое, Марта. Есть, может быть?
Thank you very much, Martha. Do you have any commentaries, questions to the speaker? If there are no commentaries, I'd like to put a question to Martha. The concept of our forum is such that the roundtables are a follow-up to the plenary meetings. And at the plenary meeting, we discussed the issues related to transnational court proceedings. And when you mentioned the judgment project, and it is extremely important. And I attended the council meeting where you discussed it in The Hague, and this is a very interesting idea of a world international convention which will comprise all those ideas. Do you think that it is possible to come to agreement within the convention between the Anglo-American system of law and continental law, because they're very different. They have very different legal systems, economic systems, different jurisdiction systems and enforcement systems as well, because some of them are interested in somehow having the upper hand, and the others would like other representatives of the country where the judgment is taking place to have the upper. Well, it depends on how you distribute the jurisdiction among the countries with different legal approaches and different economic interests. Let us be frank. Do you see any prospects for such different parties to become parties to such a comprehensive convention? I don't want to sound very pessimistic and to be very pessimistic, but I'm very interested in this idea.
Spasiba, Michael.
Thank you, Michael.
Yes, I think there are two ideas that I retained from yesterday's very interesting plenary session that somehow will be relevant to our future work. One is what Professor Bergstein said about one of the reasons why the Vienna Convention, the CISG Convention, has been very successful. And that was the attempt from the outset between the different systems of law to escape the conceptual debate and to try to come to the notions that underlie those concepts. And I agree. I fully agree with you that it will be a challenge to somehow reconcile the very different approaches that our different legal systems have in that particular area of international litigation. And of course, one thing I can reassure everyone that under no circumstances are we going to go beyond the Declaration of Enforceability, in some countries exequatur in Latin, so we're not going to look into enforcement aspects per se, because this, as you understand, would be simply unrealistic. So this is I think, one idea that was mentioned yesterday, and I thought it would be very important to keep in mind for the further stages of this project. Another one was also this pragmatic way of looking at things, and perhaps the two come together. Many speakers yesterday pressed for pragmatism and pressed for the idea that we have to be realistic about what we can achieve. And Mikhail, you know, because you were there, and all the others, I would like to let you know, there are very strong views, and this project, just to put it into perspective, started back in 1992. So it is a project with a long history, with a loaded history, and so I think pragmatism will be the key. Whether we will achieve or not, we will see.
Спасибо большое, Марта.
Thank you, Martha. Since we started speaking of pragmatism and realism in the enforcement procedures, I'd like to give the floor to Artur Parfenchikov, who is a practitioner, and he is involved in enforcing the court decision. He is the major marshal of the Russian Federation.
Thank you, Mikhail. Over the last years, indeed, a lot has been done in Russia to develop legislation in this area, and the enforcement office itself. And I believe a lot has become possible thanks to our active cooperation, bilateral contacts, and with the involvement of our office in this work. Let me just remind you that just a week ago in Cape Town, South Africa, the Congress was completed that concluded 3 years' activities of this organization and established the key objectives for the next 3 years. And most importantly, speaking about the results of this Congress and the development of the legislation and international cooperation in the area, is synchronization of legal systems of various different countries. Obviously, the forms of enforcement, legal enforcement, may be different. The French-Belgian model, then there's the Russian model, the Nordic model, the Israeli model. However, it's important, in my view, that we in our legislation include identical basic principles for the organization of enforcement procedures based on European values, the Human Rights Convention, and it's important that in the last Congress we spent time to discuss a draft international enforcement code, which sets the objective of identifying the basic principles of enforcement proceedings, and we believe that we should be aimed in the near future to aim ourselves at working under this code. And of course, speaking about international cooperation itself in the area of enforcement, which is our today's topic. As regards to the Russian Federation, of course, there are issues. Let me just note that today we have 32 international treaties and conventions in effect in this area, mostly those that go back to the Soviet times. Now, speaking about the post-Soviet era, two conventions worth noting: the '93 Convention on Criminal and Family and Civil Law, and 1997 on economic business disputes. These are the legal documents that make it possible for us to operate today internationally, and this is also, again, to repeat, mostly as regards post-Soviet times. Now, with respect to broader issues, we have more problems here, and more often than not, what we can offer organization representatives is duplication of court procedures in other countries, which is often difficult, sometimes impossible for citizens and entities to protect their interests. I could give you examples like the humanitarian area. Recently in Finland, there was a unilateral procedure established for the recognition of court rulings on family cases, alimonies, and quite a few Russian citizens are using this procedure now, and particularly as full information about this has been posted on our website with explanations about the procedures and ways to protect your interests as regards alimonies in Finland. And hopefully we will soon be able to make a relevant treaty with Belarus in this area. But for the time being, this is about it. Now, the European experience is of particular interest to us. The European Council's decision, which established the operation of the Unified Performance Enforcement Order. This is an interesting procedure. Now, in effect, I believe a few issues are involved, and we will hear about those from our colleagues today. I believe this procedure in Russia, without exequatur proceedings, operates only as regards arbitration court rulings. That is the Belarus Economic Court, in pursuant to government decrees. Now, speaking about international cooperation, and we've been discussing this very actively on international platforms. You can talk about the various levels of such cooperation, let alone the Hague Convention, and acceding to it, any other bilateral agreements. What's important today is to make sure that there's access to information for debtors in the first place on state level, and in our view this does not always require any specific agreements being made. And of course the resolutions of the European Commission in the area of justice, particularly the recommendation on guidelines with respect to more effective enforcement proceedings and the execution of the relevant decisions on court rulings and the principles to create conditions for access to the relevant information. This is of interest to us, interesting experience, and an important vector for development, and we are not part of the relevant resolutions, but we do take them into consideration in our own activities in developing our own legislation, and we could use a relevant platform to learn more about the draft for openness of assets, the way this issue is now being dealt with in Europe. As regards Russia, we could share our experience in providing openness of information on court rulings, the system we have since 1998, where all the court information is open, making public court proceedings. And I can tell you that starting from 2012, we now have an open resource. It's enforcement proceeding data bank that you can see on the screen right now. It provides some brief information. It provides for the protection of personal information, and provides data on enforcement orders, some minimum information on the enforcement proceedings, and this data bank exists as it is, and this information already today is in demand. We've now gained some 6 months of experience using this data bank, and this information is in demand on the part of citizens and the business community, particularly when talking about information about legal entities. And this information is also interesting not only for Russian users but also for international users of our website, because it's very interesting, and it can be used for contract making, for checking their counterparts. This is not Russian know-how. We've taken this from our Scandinavian colleagues, primarily from Finland, where they have had this for quite some time, a similar resource with information, fairly open information. Moreover, today, as part of our bilateral cooperation with the information posted on our website, we've published information on the relevant sources both on the Finnish office side and the Russian side. Besides, another interesting aspect of developing cooperation in information exchange, even the performance of any particular assignments, not just publishing information on assets, but the search of assets of debtors. Particularly, let me note that in October 2011, last year, we now have this 1980 convention it's taken effect now, the convention on the search of children. This has nothing to do with the search of debtors, but it's important for us because starting January this year, our office is now also responsible on the enforcement of these decisions on family cases and the search of children, and we're now very active in trying to develop tools for the implementation of this convention in our practical activities. Also, last year, the agreement between CIS countries on cross-border search of people has taken effect now. We're now working on its practical execution. And let me repeat that we are very interested in seeing these tools, the collection of information on debtors, to be active not only on the post-Soviet space, as we usually call it, but in a broader aspect, the European space as well, and maybe even broader than that. The effectiveness of court proceedings often relies on the speedy collection of information on debtors, and the collection of such information effectively impacts the enforcement of court rulings. It's important to have the information, and once the office of the enforcement office receives information on the debtor, and not only as part domestically, but also about international assets of a debtor, the position of a debtor often changes, and they may contact the enforcement agents, and sometimes the information on debtors' assets impacts the enforcement procedures. So this makes it possible for us to talk not only about civil procedures, but criminal procedures as well, including as part of fraud cases, because the existence of assets and active actions like that may mean fraud on the part of the debtor, and signs of criminal wrongdoings of a debtor. So another promising model is the implementation of an electronic trading system as part of the operation of our office. We're actively learning international experiences, including that of Finland, Armenia, the Baltic states, a number of European countries. Why? Because in our view, such an electronic platform enables us to expand the potential number of participants in the relevant procedures, and this electronic site is accessible for potential buyers not only within the country where the trading takes place, but also for participants from other countries. We are now looking for involving more users, participants from other countries, and have taken steps to arrange actions for this to become important and possible for other offices. Sale of assets now can go to buyers in Finland when the trading takes place in Russia, and vice versa. I believe this is a promising topic for cooperation. These are the key issues of cooperation that we have today in this country. I understand that would be effective to exceed the conventions that the previous speaker mentioned, the Hague Convention in the first place. However, there are opportunities here. There's room for bilateral agreements, and for the development of systems that I mentioned, information resources, electronic trading tools, so that we can efficiently use mechanisms of cooperation as part of the legal framework existing today. Thank you. Thank you, Arthur. Indeed, in the recent years in Russia, we've been having this reform of enforcement proceedings very actively, and the key issues you mentioned are about establishing new enforcement mechanisms, the search of assets, arrest of assets, and this is about the operations of the enforcement agents. This is a legal issue that emerges about how effective enforcement proceedings are in terms of protecting the debtor interests. That is, how do you find this balance? Because across different countries, you can see different approaches, and the balance is different. The question is, how strong and how long can you influence a debtor, and is it only in the area of assets or in personal area? Can you influence personally the debtor? We have measures in our legislation which may be questionable, but this is like, for example, limiting the possibility of leaving the country, the Russian Federation, and the question is how constitutional this is, and what's its place in the legal system of the country, first and foremost in terms of protecting human rights. So this balance of protecting private and public interests, in many cases, in most cases, and in every specific situation, is identified by courts. And you have the enforcement agent who may be who's told by the debtor that you got to go to court, and it's up to the court to decide. So it's about the balance between public administration efficiency and the enforcement of a court decision, and how constitutional this is, and how sufficient and necessary are the measures.
And thus, it's time to give the floor to the judges to express their opinion. I'd like to give the floor to Mr. Vidzan Mandé, Vice President of the Constitutional Court of France. Thank you, Chairman. It is a great honor for me to speak here among you, among outstanding professionals in this area. A few words on the enforcement of court decisions and rulings. So I'd like to share my experience and the experience of my country. And I think that what is most important is execution of judgments, not only within one single country, but also within other EU countries. And France is concerned about it since it has become member of the European Union. Jurisdiction is of importance, obviously, and we should foresee certain limits which are there. And with this in view, I'd like to mention two decrees of the European Union. That is 22nd December of the year 2000 on the legal competence and civil law and commercial law, and the Brussels decision number 1, as it is called, and also the 27th November 03, the decision on the competence and recognition of taken decisions in terms of succession, and also the responsibility of parents, the so-called Brussels Decree 2010. in addition to the decision mentioned above. These texts were of great use to many people who executed decisions of the court in various countries of the European Union. As to the mechanism of mutual recognition and facilitated mechanism for enforcing court rulings in civil and commercial disputes, we can say that the law enforcement horizon is very broad because it involves various sectors of life in the European countries. The principle is very simple. All the court decisions should be executed because we are moving towards convergence of interests of various countries. Though yesterday we emphasized that the countries do not imitate the systems of each other, and there are contradictions, certainly, and we should bring into compliance and harmonize those systems. There are a lot of, so to say, mechanical problems, but convergence is a phenomenon which is certainly developing. And there are single standards, unified standards for decision-making. But for this, it is necessary to recognize the important decisions or decrees taken in certain countries, which have been already confirmed and endorsed. So the principle of universal recognition of mutual decisions is indispensable. We are moving towards a system under which there will be no control or verification in case of appeal or by a party. We are gradually moving towards this because the decisions will be mutually acceptable. It cannot be achieved overnight, and there should be a stage-by-stage approach. But the first thing is there should be no appeal, because we should accept the decision of another party. We should send a request to competent authorities, and we should use the decision taken abroad. Certainly, we should verify the decision itself in terms of its validity and so on. That is, when all the documents have been collected, we can execute the decision without any doubt or obstacles. Besides, the respondent should comply with the decision taken, which is clear, but though there should be a possibility of appeal. But this is what is contradictory, because the judge has to reconsider the decision taken abroad in case of protestation or act of protest or appeal and so on. But certainly it should be done within a certain time frame, and you should not delay the execution. When the ruling is taken after the grounds for appeal have been studied, and the court decision should be either in favor of the respondent or plaintiff or the court that took the decision. If there's no agreement, no consent, we should try and resort to reconciliation procedure, because there is experience in many countries, and we are searching a way out. Certainly there may be kind of deadlocks, and we cannot find a way out, and we cannot accept certain provisions, in terms of certain documents, papers, and so on. As far as family law is concerned, family disputes, or in case of hereditary heritage wills and so on. So, for example, when we have to return children who were illegally transported from one country to another, in these cases, we can directly apply the court decision in various countries, and there are no discord in this place usually. There are very few differences. Certainly we can verify authenticity of the certificates and papers, but this is a technical formality. It is the court and the judge who takes a ruling, and it should be executed immediately. Oh, what problems are there when it concerns, for example, pensions or debts in family disputes? A lot of things are regulated by the Hague Protocol of the 23rd November 2007. This is a regulation for pensions, also all the alimony and so on. So this is direct application of the law, and no special declaration is required. You don't need to send a request, etc. This law has direct application, and there are other situations which are more problematic, like disputes, like debts not covered by the regulations available, maybe banking debts, and we need a special mechanism for banks because we need a specialized decision by the country of origin of the debt, which will have specifically described the liabilities confirmed by notaries, and also the liabilities which are voluntarily assumed in case of a transaction which, for example, consisted in providing a credit or a loan, etc. Even in case of absence of a defendant or a respondent when the ruling was taken on his debt. In this case, the execution is mandatory, and in this case it is equal to commercial transaction disputes because the form it takes is accepted by all European countries. The decisions are directly applicable without any additional agreements or explanation, etc. So the force of applicability is 100% proof, and no pretexts or explanations are accepted. So measures have been taken for enforcing debt payment, or for example, the claimant goes to a competent judge who accepts the claim and then uses an appropriate rule or regulation in case he doesn't see any problems with this, anything which may be suspicious. If the respondent does not accept the ruling, then the procedure starts in compliance with the court proceedings, which take place under administrative law. If there are no appeals, then the judge automatically, in accordance with the Brussels decree, uses the procedure of paying the debt, and there are no additional court proceeding in case of no impairment or encumbrance. And there's a special procedure which accelerates certain trans-border disputes or claims if the amount of the claimant does not exceed 2,000 euros. It is regulated by a European procedure of small disputes, and it takes place in another member states where law is applied without any additional declarations or other procedures. If there are no claims on the part of the respondent. So thus, in terms of mechanical approach, we have more progress, somehow reducing the delays, the procedures, and in midterm, we would like to simplify the execution part or stage. There will be no verification of exequatur, because if the documents do not contradict each other, there should be no additional verification. All the procedure should be automatic, and then the papers or data will be considered as confirmed according to the decision by Brussels. And it deals with the civil disputes, commercial disputes, and thus we accelerate the proceedings, which become more efficient, and it does not require additional expenses. The United Kingdom, Ireland took similar decisions on participating in such activities, and they're preparing special documents, so it will be applicable in Ireland in compliance with the agreements with the European Union. And in the long term, we hope to have a special regulation which will deal with the competence of law enforcement and so on, and also authentication in terms of succession. There'll be special probate certificates, and we'll have to define general and acceptable criteria for patrimonial relations, and to bring it into compliance with the existing legislation, and to see what differences we have in transborder context, whether it needs to be linked to the residence, while in terms of getting the inheritance and succession. If a person deceased and he lived in this particular country, we won't need any confirmation. We will do it in an administrative way, just defining certain provisions which will be certainly contained in all the papers related to inheritance or bequest. Well, it is a long-term prospect because a lot depends on the national courts, and they have to accumulate experience and to see whether national criteria are comparable in this case. We'll have to formalize the procedure, but I hope that in the long term we will be ready to use it to the satisfaction of all European countries. Certainly, we had to start this work because we should move to another level in terms of the regulations needed to provide for independence of courts And taking into account a lot of innovations into countries becoming members of the European Union, taking into account very intricate procedures, not complying with each other. So we should do something to accelerate court decisions and not to have any delays in trans-border cooperation. Thank you for your attention. Thank you. I think that was a very detailed presentation, a very comprehensive presentation, which was in compliance with the call of Ventura Legovic, who called upon us to describe the innovations and novelties in the system, and in particular in terms of bringing closer approaches of various countries, and also in terms of sovereignty of the systems. The European Union has existed for a long time, and it unites and comprises countries having similar economies and structures, but still there are problems in terms of bringing closer the court systems and enforcement systems, which is extremely important for Eurasian space, because we're also moving closer to each other. And certainly a lot of things are to be discussed and harmonized, because these countries have very long historical traditions and legal systems in particular, though we encounter a lot of problems to be resolved. So going back to Russia, our contribution to the harmonization of systems is made not only by lawmakers, but by courts proper, by courts themselves. And it is interesting because historically in the Russian Federation we have had the procedural rules which imply that we should have an international treaty to execute foreign court rulings. But we don't have many treaties like this. We have a higher arbitration or commercial court which used its will to apply the system of direct application of international law, which is a kind of international compliance. In those cases, which became a matter for consideration by higher court instances, like the Supreme Court, Supreme Russian Court, or arbitration commercial court, and they started directly applying international rulings without any international treaties to the effect, though the norm or the ruling of the law was retained as it used to be. So I'd like to give the floor to Tatiana Andreeva, who is Deputy Chairman of the Higher Commercial or Arbitration Court of the Russian Federation.
She will tell us about any future developments of the court. Good morning, dear colleagues. Let me take this opportunity to identify the few issues that we could discuss in this audience without making a formal report on the topic of our today's roundtable. Russia is integrating in the international economic space so quickly that we are doomed to interactions and cooperation in this area as well, legal and economic. And I believe that the legal regulation of cooperation and interactions in the judicial area is lagging behind the economic cooperation. Objectively, we're not coping with the pace. Yesterday, at the plenary meeting and the roundtable we had, headed by Anatoly Ivanov, it was noted that this is not to say that we gotta wait. I mean the bodies, the agencies responsible for enforcement. We should not wait for a law, a relevant law to be enacted. Why? Because as regards enforcement proceedings, what's important to consider is that the right for enforcement is a value that assumes certain protection, the development of tools to for a court ruling to be enforced, and the court should have the right to use its own activity to act within certain boundaries to protect the right of enforcement. And what was articulated yesterday as well and was touched upon today, what are the boundaries for this judge's right to implement this option? I believe that the boundaries rely on the need to protect key human rights and freedoms. These are the boundaries within which the judge has to be active. And the issue of enforcement proceedings can be viewed in two aspects: internal enforcement, that is court enforcement by Russian courts as part of the enforcement proceedings, and then the execution of international foreign court decisions. In both aspects, there are interesting approaches developed in practice, including the arbitration court practice, something that the audience here will certainly discuss, and the enforcement of rulings enacted in the Russian Federation goes through two mechanisms: the enforcement agents, the Ministry of Finance, when talking about using state budgets of various levels, and then this budget, the Treasury funded cases involve pilot decisions, including European courts, and there's a good mechanism developed here for compensation for cases not being enforced on time. We've had this law for more than 12 months in effect now, and I believe that we are in line with the practices of the European Court of Justice, and this mechanism is being successful in both general jurisdiction and arbitration. So, of the objectives of implementing the objectives of this law, the federal budget annually allocates significant funds, reserved some 15.7 billion rubles in 2011 to enforce court decisions if such decisions involve any funds to be used from the state budget. And this ministry, the Ministry of Finance, spends 1/3 of what is allocated. So here, in terms of ensuring the obligations of international treaties, the performance, the enforcement of decisions do operate fairly well. And as regards to the enforcement proceedings by the enforcement agents, this mechanism does not exist. And there are questions regarding the equality or inequality of the participants in the process in a court, where in one case you have guarantees on a legislative level, in other cases there are no such guarantees. So what we use here is different court control means, but this doesn't really impact the result, because in the absence of legislative regulation in the area, we actually de facto, not de jure, we use this mechanism extended on enforcement where the court warrant is done this way. The agents may not like it, but this is based on the need to for court protection to be possible, for the rulings to be enforced. In February 2011, we've adopted this difficult resolution, because an arbitration court decision was not enforced for 10 years. So I understand an error was made, and the enforcement agent received the funds on his bank account, but by mistake, the funds were remitted to the wrong person, not to the creditor. So the situation is difficult. The debtor fulfilled with its obligations because the funds were remitted to the enforcement agent, while the mechanism established for providing enforcement based on the enforcement office. And while the claimant continues to claim, because damages are still there, they're not compensated yet, and the decision, the court ruling, is not actually performed yet. In our courts, the Presidium of the High Supreme Court of Justice, there was this decree of February 2012. They took the risk to state that we can rule a compensation, and because there's a fact of long failure to comply with a court decision. So I'm not urging you to use this approach everywhere, but considering specific situations, in the absence of any other mechanism to enforce a court ruling, this is a form that can be used to provide apologies to the claimant. This is one aspect, and I believe there's room for further improvement of the legislation once the Russian Federation has more financial capabilities of acting. We could decide how to enforce. Is it obligatory enforcement? So there's a room for improvement here. The other way is the enforcement orders. Of course, ideally, when you have an international agreement, that's great. But life is much more complicated than that, and knowing about the rights of the court, the obligations of the court, a ruling has to be taken, and courts need to find ways to make sure court rulings are executed. And the Supreme Arbitration Court was brave enough back in 1997, enacted this decree explaining, providing explanations of procedural law provisions, and believed that it can be interpreted in such a way that in the absence of international treaty, still court decisions from other countries can be enforced in the Russian Federation using general principles and norms of international law, including that of mutuality. That was back in 1997 when the Supreme Arbitration Court developed the draft procedural code. We've included a relevant provision in the code, but the legislature did not support us. there were objections, including those from the public, academic community, and we still have this norm about arbitration courts considering the international court decisions if provided for in international treaties. This is a classical formula. What's interesting, one of the arguments that opponents used against it was that we will put our judges in a difficult position, whereas they have to establish in the country where the decision needs to be enforced in the Russian Federation, to establish actions with respect to the Russian decisions. Was relevant action taken there or not? So the search of information may not always be possible. Information is not always accessible. So we failed to defend this position at the time, to have it adopted in the State Duma. So life dictates its own rules to us, including those regarding this integration process in international trade and civil commerce. Trading transactions are very wide with many countries of the world, so participants in international commerce and trade may be in a situation where when you have a conflict, there's no guarantee that a court decision is not enforced. This is not reasonable. This doesn't take us any further in terms of the accession of Russia, maybe in the European Union or something, and makes it difficult to move further in economic development and providing guarantees for economic development. And so I believe that the Supreme Arbitration Court was fairly consistent in its decision back in 1997, and now the arbitration court practice is such that we do not exclude the direct application of principles of enforcement in the Russian Federation of foreign court decisions, and Valery provided this positive example of cooperation with Finland, and he also mentioned its unilateral obligation in the family area, family law, and as regards the commercial law, in 2011, the Moscow Arbitration Court made the decision to enforce a ruling in the Russian Federation to claim a monetary debt according to a ruling of a Helsinki district court. So in practice, we already have this approach, this principle in practice, and I believe we cannot do otherwise, because as an judge, I would not want my decisions, my rulings, not to be enforced. Otherwise, what's the point? There's no legal protection, no remedy. So this is how we should view the decisions of our colleagues in our country and in other countries, based on solidarity, if you wish, international politeness. We need to respect the decisions of our Western colleagues, even using mechanisms of exequatur, and if you speak about any checks, you should not go beyond any check of public interests, because anything else was checked by the judge, by the court of an international country, a foreign country. So this is the approach we have in practice, and if there's a will of the legislature, they will set this in law and international treaties. Thank you.
Thank you. I think that this is just the right way which we should take up and follow. So if you have any questions, you are welcome to the speakers and presenters. Valeria Abramovich, you have the floor, please. Please take a microphone to put your question to the presenters. Colleagues, I'd like to support those ideas promoted by Tatiana Konstantinovna in compliance with case law of our Supreme Arbitration Court and the European Court of Human Rights. I'm aware of the situation we had when we were preparing a draft arbitration code, and there were a number of options. We could accept the provision to execute decisions on foreign courts in those cases when a treaty to the effect was not available. In this case, we should stick to international politeness rules, so to say. So now, this text is non-existent in the code, but I'd like to cite two rulings of the Supreme Court, and in one of them, it said, since there's no international treaty, we should not enforce rulings by foreign courts taken by them. And about O2, the same panel of judges stated it differently. And they took the British ruling of the British courts and they wrote that since there's no treaty on mutual court decisions enforcement, does not mean that we should not execute this decision. And as the British say, a lot of water has flown away under the bridge. And now it has become mandatory with us. Quite recently, I think it was the Russian edition of the bulletin by the Human Rights Court, which published the decision of the European Court related to the Russian Federation. It cited this decision and it said the absence of a treaty does not preclude the execution of a foreign court decision in the territory of the Russian Federation. And so I think without a new law, even now, immediately, we can apply it. So the situation is contradictory because on the one hand there may be an international treaty and then the court system of Russia has to enforce the decision since it's a party to the treaty. If there is no treaty in place, then the enforcement is not excluded. In each particular case, it should be decided on a case-by-case basis as a matter of politeness and mutual respect. So we can comply with it even now. And as Tatiana Konstantinovna said, they are doing so, and I think they are right. I have a question, if you don't mind. My question is to Artur Parthenchikov. Tatiana Konstantinovna was right saying then each judge taking a decision is always concerned about its enforcement. And since I'm a chairman of the Pavel Astahov Collegium of Lawyers, I'd like to put a question to you. So now, this country has become an active member of the community in terms of transferring children residing abroad, not in the territory of the Russian Federation, being citizens of the Russian Federation. Do we have any positive solution of such a problem or any experience if the Russian Federation took a decision on transferring the decision to the residence of a parent, but at the moment the child is residing with the other parent in another country? So have we been successful? No, we have not executed any decision of this kind yet, and we haven't got any experience. I can state that the appropriate convention started working at the end of last year, and we comply with the functions of the so-called enforcement procedural search, though it is not required. Perhaps the child can be living with one of his parents. It's a matter of court enforcement, and that's it. As far as the search of children is concerned, it doesn't have anything to do with the international court procedures, because over the 3 months of our work, we identified more than 30 children which are being searched by the law enforcement authorities, but mostly it relates to the procedures of enforcement of domestic courts decisions. I hope that a special department will be set up engaged in the search of children, and under the auspices of which there will be a specialized group dealing with international problems, and not only in terms of looking for children, but also in terms of finalizing certain aspects of searching for debtors, property which has been seized, and so on and so forth. I think that we will elaborate the appropriate mechanisms in compliance with the presidential decree on creating such departments. Soon it will be signed after the consultation with the government, and then we will be able to work more efficiently in this direction. Martha Pertega wanted to say something. You have the floor, lady.
As this relates to the 1980 Child Abduction Convention, I take again the floor to say that, well, in Russia, but also in all other contracting states, the ratification by Russia has created very high expectations, and acknowledging that all those cases dealing with child protection are very delicate cases, we believe that we offer the safeguards and the guarantees in the context of that convention, and the fact that Russia also agrees is a very important sign that only underlines this conclusion. I can only add to that it will be extremely important, as my colleague was saying, that in Russia there would be a specialized unit that would centralize those cases. In the Hague Conference jargon, we call this a central authority. It is of a very great importance on a practical level, and I will not hide to you that other contracting states are really waiting for that step to be taken before they really are able to, on a practical level, operate the convention. My colleague Louise Ellen Tights, who is sitting on the third row at the corner, is responsible for the 1980 Child Abduction Convention at the Permanent Bureau, and she'll be happy to discuss in any further detail those matters with you. Thank you.
Сергей Михайлович, да.
Sergei Mikhailovich. Thank you. My name is Sergei Minsamay, Deputy Head of the Department of Cultural Heritage of the City of Moscow. I don't know who will answer my question. Quite a lot has been said today on the execution of foreign courts' decisions, and in private law in particular, in family disputes, commercial disputes in particular. And I'd like to ask foreign colleagues, what prospects do we have for the execution of foreign courts' rulings in the administrative violations and law? Because all legal systems take decisions on sanctions, penalties, and the prospects for recovery of these penalties in the territories of foreign countries is very problematic and doubtful, because there are no international treaties to the effect, as far as I know, and there's no case law. And I know that sometimes a legal entity is an owner of a cultural heritage property, and we bring the matter to court, but there are no chances for being successful in such disputes. Do you consider that it's realistic in terms of administrative liability, because the right to decide upon such issues usually belongs not to the courts but to some administrative bodies or administrative officials which, in compliance with the national legislation, are entitled to to decide on such issues? Who can answer the question, or is anyone willing? I can do it, but I'd like the presenters to do it. Artur Olegovich Parfenchikov will do it. Well, I think that this is an obvious problem in terms of cooperation, in particular, cooperation with the border states, and where the borders are open. And we would certainly be interested in the approaches in the European Union to it. Between, for example, Russia and Belarus in the border areas, people live practically in two countries at a time, and they have free movements, but they can certainly commit any kind of violations and administrative ones, administrative offenses in particular. But if we have certain visa procedures in our interstate relations, then it makes it different. And now it's under the discussion. We can, for example, close the entry for those citizens who have offended or who have not executed certain administrative decisions taken in the territory of Russia. And we can create appropriate procedures for recovering penalties, debts, and so on, while we are issuing visas. So this is a mechanism which I hope will work in the near future. And certainly this is a problem, and it should be addressed. But it is problematic within the format of bilateral treaties. It should be multilateral. And as far as judicial officers are concerned, so administrative sanctions amount to half of all the court rulings that we get. And as a rule, this is not a court ruling proper, but this is a decision by certain administrative officers. But this is execution of punishment anyway. And in this case, it requires very serious international procedures and mutual truths. And I don't think we can speak about international politeness in this case. I'd like to take up this opportunity to say that the Morocco Minister of Justice has joined us, and we would like to give him the floor if he wishes to say something. And also, I'd like to add that, following up Mrs. Andreeva, when the so certain administrative or state-level centralized decisions are executed, then there are some strange things emerging, because you never know whether the state itself will be violating law. And you'll have to reimburse money to citizens in case of such governmental violations. And another issue is harmonization of procedures for recovery at the expense of the state budget. When a writ of execution is sent to the Treasury and judicial officers or enforcement agents do not participate in it, it is the government of the state itself who should reimburse it to citizens. And we have to involve those procedures which are existent for private execution, and we have to recover debts using state-owned property, if it's the debt of the Russian Federation, which is recovered in an enforcement way. And these mechanisms should be very specific, and we should go cautiously, or we should go careful about it. It depends on the legislation, the way it has it in each country. And if we have no comments or questions, I'd like to give the floor, going back or down from the court level down to the pragmatic level, enforcement level. I'd like to give the floor to John Wisseborn, who is the head of the Netherlands Royal Association of Notaries. And we discussed these questions in Holland. Mr. Wisseborn said that they have a lot of work for enforcement agents or judicial officers who prepare documents and so on and so forth. And since the Netherlands is a very active country in terms of commercial transactions, and there are numerous companies which are registered there functioning in other countries, I think that the function of judicial officers is of utmost importance there. So we'd like to know how you cope with it in the Netherlands. Mr. Wisseborn, you have the floor, please.
Thank you very much. I prepared a little presentation. It's more to help me than help you. We heard a lot about taking away legal borders for the possibility of enforcement. And I have to state that is only one thing. Really, to make it a success, the enforcement has to be a success in the end. And the way of that success is depending on the expectations of the creditor or the plaintiff. So it is very important that you know about the possibilities and more than the impossibilities of the foreign system. So I'd like to explain to you how the enforcement in the Netherlands is being taken. It works. We have about 16.5 million inhabitants, and per 100,000 inhabitants there are 102 attorneys and 10 judges. And when you look at the end, there are only 250 judicial officers, which is very few, but we work very efficient. As you maybe know, in Holland the judicial officer is an entrepreneur, and it's been constructed as a commercial business model. So the Dutch judicial officer is only getting paid by performing his official tasks. In 2001, our system has made a new law, and it's all about market-oriented thinking. There has to be competition between judicial officers. All of our judicial officers are competent in the whole of Netherlands. So, in fact, every judicial officer is a competitor of the other judicial officer. We have a professional organization. As I already stated, I'm the chairman of the board of this professional organization. This professional organization has the obligation to look after the good performance of our duties and is formally for the public interest and not for the interest of the judicial officers. In Holland, the official tasks are combined with other practices. As you see here, we have debt recovery practices, which isn't an official task, but is a logical complement of our official tasks. Then again, we do civil service. We think that's a very good thing, because when you are at the starting of court proceedings and you are especially involved with court enforcement of court decisions, then it's more easy to learn that sometimes it isn't useful to go into court, because we already know that there are no possibilities of enforcing, and then we are able to stop the plaintiff or advise him that it's maybe not so advisable to go into court, and that the first gain is by not making all those costs. And learning afterwards, learning after you get a court decision that there are no possibilities to get your money, it's more frustrating than hearing it in advance. We are also acting as an attorney at law in our primary court for sums of money about 25,000 euros, and in the end we are related to the enforcement of civil judgment. Speaking of the enforcement, most of the enforcement is done by the judicial officers, but there are a few other involved. The public notary is involved with enforcement of immovable goods. We have state-employed enforcement agents only for enforcement of tax decisions. And then we have a very small task for the courts for sea ships and airplanes, and that's only important for the international recognitions of the court decisions. In the Netherlands, the principle is that the debtors, all of the debtor assets are liable for execution. So everything you have can be executed by a creditor. Certain assets that are closely related, I will go into that later, cannot be sold off, but it's very limited. Our Supreme Court stated again and again there is a strict interpretation of this principle. So, as I see, every debtor is guaranteed a minimal income. There is no possibility to try to expand that minimum. Then again, the state, who can make their own rules, they can touch the minimal income. They can do it with special measures, and they can use credit space. The normal creditor can't do that, but our state can do that in tax situations. Our Dutch code gives detailed rules for the service of judgment. Without proper service, the whole enforcement is void. As I told you, it's more efficient to have that combination of service and enforcement. As I said, as a principle, the court is not involved in enforcement. One has to seek judgment if there are objections. So in principle, the enforcement agent does his tasks, and only if there arise problems, then there will be a task for the judge. There's one exception. Being entrepreneurs, being a commercial business, in our law it is stated that our judicial officer has to perform his official duties when someone is called upon. In some cases there can be a problem when on the one hand you are forced to execute, and on the other hand there are certain legal issues and you are not certain that in this case an enforcement can be made. Our Dutch code provides a very special court decision. The enforcement agent makes writings of the problem involved and can make proceedings against the will of creditor and debtor, and they have to go into court to get a court decision about the problem which they not stated, but with the enforcement agent stated. And that's the only exception of the rule. So there's only involvement of the court when the dispute arises. Enforcement on movable goods. As a principle, every goods can be seized, but there are some basic goods. But it's very limited. Bed, food, clothing. And some pressure groups in Holland, they want to have all basic goods to be exempt of those principles. A nice example is that in Holland we can't enforce for food for 1 month. But then again, we can enforce the refrigerator. So there is a problem because, well, the goods, they can't be seized, but the refrigerator can, and then the other thing is not so effective. A judicial officer can go to financial institutions as banks and obligate them to disclose whether there is a deposit box. And in some kinds of farms, livestock and that kind of thing, there is a special caretaker which can be appointed by the court. I have to go back. Yes. If there are more creditors who seize the goods, the judicial officer who had actually seized the goods the first time, they will sell them off. And as a principle, the judicial officers will divide the spoils. The court is not involved, only when a dispute arises, the court is involved. And in our law, it's very interesting because one of our speakers before told you about a problem that arose when judicial officer paid to the wrong person. In the Netherlands, in such a case, the state would be liable and the creditor will be reinstated by the state. So the state is liable for all mistakes a judicial officer makes in performing his official duties. Garnishment under a third party is very common in Holland. It's easy to do. The judicial officer goes to the third party and hands over the garnishment. The third party has to fill in a special form. He has 4 weeks for that to disclose the relation between him and the debtor. If he doesn't do it, it will make him liable for the whole payment in the court decision. So it's generally making the third party the debtor. Seizing wages or social benefits is a major part of our enforcement process. And this becomes extra big of a new possibility in our law, which gave judicial officer access to social security data. So if there is a debtor who has a normal job, then he is, as we call it as Dutch enforcement agents, he is a sitting duck. The judicial officer is responsible for collecting the money. And again, the judicial officer is dividing the money. The court is only involved when there is a dispute which arises on dividing the money. One of our new developments is the electronic garnishment. It's already made possible in our law. It's made possible 1.5 years ago. But the third party has to make arrangements in order to receive an electronic garnishment. And we hope in the next few months, one big party in Holland is able to receive electronic garnishment. It's more effective for the third party because, as you see on this slide, the third party has a lot of things to do. He has to fill in the form and he has to make a lot of arrangements, and when he failed to do it on time, he will be liable. Electronic garnishment will be not only the garnishment itself, but we will get a data set which he can use in his own systems for making handling the seizing, the garnishment more easy. And then at last we have the enforcement of registered goods. You have immovables, ships and airplanes. Judicial officers seize the goods and draws up a report, and we deliver it to our public register. And then it's impossible for the debtor to sell the goods without the permission of the creditor. For the real enforcement of the goods in the Netherlands, the notary is responsible. He is the one who makes the sale, and he is the one who divides the spoils. I hope that this short overview, which is very short as I state, helps you to know more about our Dutch system. And as I said, it's the enforcement agent who make the realization of the rights. When you have a court decision and it can't be enforced in practical way, then there will be much frustration and you don't have anything gained by making all the international borders go away, because in the end people are only interested in what they get out of the decision and not have the decision itself. Are there any questions?
Да, если нет никаких...
Unless there are questions, I'd like to ask Mr. Visseborn, Holland, well, there's two systems, the state enforcement system and the private enforcement system. And the Netherlands have chosen this one. In Russia, we've been discussing this for a long time now, and maybe we should implement a private enforcement system as well. What Mr. Visseborn has shown us in his presentation is that this enforcement system is a kind of a business model, because some of the services are in demand, others are not. There's some competition, some profitability. This is all based in economic terms, and maybe this is the right way of doing this. But the question is, when in Russia we talk about whether we need a public or a private system, it's mostly about social collection, social claims like alimonies, questions regarding damage to health and life, and claimants are usually people who are socially unprotected people, not able to pay to their agents, so the agents are active enough for the claims to be enforced, while the public system provides some hope for such people to get protection. So it would be interesting to know, how does it work in such a private system as the Dutch one? How does it work, this additional social work of the enforcement agent? Or is it a pro bono work? Or is there any other way that this works?
Pro bono work, but your example of alimony, in Holland it's quite common to make a special institute, and for the enforcement of decisions regarding child alimony, we have a special institute who tries to get it amicable, and if that doesn't succeed, then they are the one who addresses the enforcement agent. So there is a payment from the state, and they, because of they are a big party, they do all the alimony business. It's for the judicial officer, is it a big client? So they choose a few judicial officers which they do business with, and then it is an interesting client, and that's the way how they make a way of doing things. As I stated to you before, the system has its disadvantages but has a lot of advantages. One of them is the efficiency. As I told you, we have 6.5 million people living in the Netherlands, and we have only 250 judicial officers, and we have some assistants, but everyone who can perform official tasks, it's about 900 people, and there's no problem in the enforcement whatsoever. There's really harsh competition. Every judicial officer wants to perform tasks, so it's no problem to get someone to do that official task. And what other advantage is that the payment of the judicial officer is done by those parties who use the legal system, and it is not paid by the taxpayer. And if you take into consideration some parties who have a lot of contracts as phone companies, they go a lot of court proceedings and they use a lot of tasks from the enforcement agent. They are the one paying it, and they try to get their money back and the costs back from the debtor. But a taxpayer who has nothing to do with it isn't involved, so he doesn't have to pay for the problems which were caused by this telephone company in making all those court proceedings.
Yes, please. You have a question. Thank you. Arkady Leshchenko, Arbitration Court, Moscow area. My question is this. Since in Russia, enforcement agents are public officers, then they can go to court to claim, and there's a limited term. So in Holland, since this is a private office, how does it work, the protection of debtor interests, if the debtor does not agree with the actions of the enforcement agent?
With these cases, there's only two aspects. The one aspect is the claim itself, and the other aspect is the operation of the judicial officer. So if someone has a complaint against the judicial officer, he doesn't perform his duties right, then he has the possibility to complain about it at our Dutch court. We have a disciplinary court. There's no court fee, there's no lawyer involved. Everyone can write even an email to this disciplinary court, and then the judicial officer has to defend himself. When there is a problem about the claim itself, the judicial officer is between parties, and he will have to direct the debtor to what his rights are and how he can defend himself against this action. And if he doesn't do that right, then you go to this disciplinary court to complain about the behavior of the judicial officer. But in practice, this works very well, because being a private enforcement agent, the judicial officer knows that he's looked into. And when the debtor has a complaint, the judicial officer will be very interested to read him his rights, because when he doesn't do that, everyone will say that he wouldn't do it because of his commercial interests. So in practice, being wat is nou verdacht? Well, everyone thinks he wouldn't do it because he has a commercial interest. That being the fact, he is more driven to give people his rights. In Holland, we have an enclosing form with all of our official papers being, well, even for Dutch people, it's not very easy to read. And we made an enclosing form where we try to tell the debtor in more popular words that what is taking place and what his possibilities are to defend himself. So in practice, we don't have any problems about that.
Yes, please.
You mentioned in your last slide that there might be problems with regard to arrest or execution into registered goods, ships, for example. Does this mean that in the Netherlands, a ship which is registered in the Netherlands could be arrested even if it is in fact situated abroad? Has this created any problems with recognition of such arrests abroad? And would, on the other side, in the Netherlands, a similar arrest of a foreign registered ship by a foreign court be recognized?
This is not a very simple question. The problem of ships, it's on the slide of immovables, but it is movable. That's the problem with the ship. It's not often that creditors will try to, when a ship is seized abroad and it goes to the Netherlands, many creditors choose to make a new garnishment, because that is less hassle than trying to get the foreign seizure, get it recognized in Holland. When you have to go to the court and you have to get it recognized, it's more easy to ask a judicial officer in Holland to seize again under Dutch law. And as I stated, we have unregistered boat, which we garnish just like movable goods. We have registered ships. We garnish them like immovables. But if it's our foreign ships, then our courts are involved. And that's because not every system knows a notary. And then it's more easy to get recognition of selling the boat and being the new owner and having that in a court decision, because every legal system has any recognition of court decisions. So it's not, well, it's a bit of making advantage of every system had the possibility to acknowledge court decisions. So there is really not very much work of recognition of foreign seizures, because it's too much work. It's more easy to get it seized again under Dutch law by a Dutch enforcement agent.
Есть еще вопросы?
Any more questions to Mr. Wisseborn? My question is as follows. Do engagement or judicial officers in the Netherlands engage in enforcing private decisions, administrative decisions, criminal courts decisions which are related to certain punishment, like penalties, etc., not certainly imprisonment, but which relate to taxes or things like that? And another question is, if you have to recover all the money and you have a specialized authorized judicial office, but the debtor has some other liabilities of private nature, and in this case there's another enforcement agent or judicial officer who's dealing with it, and how you coordinate their activities in this case, and which is given priority, alimony or other liabilities, or is it just competition that decides it? Do you understand my question? If you have any statistics, could you tell us how many judicial officers in Holland complete their cases successfully in terms of execution or enforcement annually?
To start with the last question, being chairman of our board of the Royal Association, the problem for us getting figures is we are competitors. So being in a field of competition, you're not you're not very tempted to tell your competitor how you are doing. We made a bylaw which made it possible that we can get these figures on an anonymous basis. So there is an in-between office who collects all the data and will anonymize this, so we can have figures for this kind of questions. The problem is this bylaw, we made it 3 months ago. Our Dutch minister still has to give his accordance to it, and then it will be it will work. And for our own office, I can tell you we have a success rate which varies a bit, about 70–80%. So 70 or 80% of all money which has been stated in court decision is actually regenerated, which is, I think, a very high level. You asked about competition, how does it work when more enforcement agents connect to the same debtor? This is not a problem, because when there is, as I told you, seizure on wages, the judicial officer who made the first seizure, he is the one who has to collect, and he has to divide against all creditors. So the second or third judicial officer, he seizes the wages and he just goes to the first judicial officer and tells him he has to take into consideration, and he just divides. Whether someone gets a part or gets anything, this is voorrang.
Als je voorrang voor preferentieverordening.
Yes, we have privilege enforcement. Our Dutch taxes, some claims of the states, they are privileged, so they will get 100% in the dividing, and after they have been completely enforced, then the other creditors will get according to their claim. Your first question was about are we performing official tasks in criminal law? We only perform tasks in criminal law where it comes to the recovering of money. One of our greater success in the Netherlands is the system who collects speeding tickets. In Holland, when you have speeded and you have get a fine for that, it's taken out of the criminal system, and we have a Dutch institute who collects these money, and if it isn't paid amicable, then it will be enforced by the judicial officer. And again, this state organization chooses a selection of 10, 20, 30 judicial officers which they do business with, and they can get sharp prices, and we have a very big success rate in regenerating all that speeding tickets. But we are not really in criminal law itself. We do some administrative law, but then again it's only fines for not complying. When you're not complying to a court decision, you get a fine for that, and the Dutch enforcement agent collects that fine through enforcement of goods or wages. So it's only in general about the money.
Спасибо большое.
Thank you. Any more questions or commentaries? If there are none, I'd like to give the floor to the next speaker, who is a representative of the advocate of this private execution system, a kind of ideological center which spread the system over a lot of other countries. Mr. Lashkar, who is president of the National Chamber of the Judicial Officers of the French Republic. Thank you, Chairman. I'll answer all your questions that you might have, which deal with the activities of our professional community in France. But by way of beginning, I'd like to somehow shift the emphasis of our discussion, and it relates to all the presentations that we have heard, because we should coordinate and harmonize our works. But before this, I'd like to thank you, and through you, all the organizers of the forum who asked the National Judicial Chamber in France and suggested discussing international aspects of law enforcement. And I cannot do it in a few minutes, because there are so many various issues which are of utmost importance for any law-based state, but I can share with you some of my ideas which relate to our experience in international area and in the European area in particular, in order to improve the functioning of judicial officers and to improve international aspects of this profession. Certainly, there is a kind of a French paradox. On the one hand, we have enforcement of court decisions. This is a major way guaranteeing the efficiency of our subjective rights. Otherwise, why do we need courts at all if their decisions and rulings are not executable? On the other hand, we have hopes for a fair justice. And the European Court of Human Rights in 1998 included this requirement for fair judicial consideration in its convention or protocols. And after this, the European Court included also the right to enforcement as an independent right beyond the civil proceedings, because it became valid even for notary acts. And while the national right for enforcement may be disputable, and it is linked to exterritoriality, application of exterritorial application of this rule limits its effectiveness and efficiency, and it is also due to sovereignty. Thus, sometimes this task is given to the judicial officers, And as to enforcement abroad, it depends on the mandate of the judge who made the ruling, and also on the certain limits that exist within the country where the decision should be executed. And the legal assistance should be provided abroad. The creditor should know it and should know what to do in this case. It depends on the country because national legal systems vary, and the right for execution for creditors for recovering debts abroad are least predictable, which is paradoxical because it relates to the sovereignty of the state. So the creditor should know which rules exist abroad, where to go, to which instance to go, and what strategy to choose for recovering the debt. There's another problem. How can we use available means and methods abroad efficiently? Because in all the countries besides the European Union, which has case law and procedures and whatnot, sometimes the rules and their specificity are not acceptable for foreign creditors. Certainly they can go to some specialized offices, bars, lawyers, and so on, to get the information. But the decision may be not to the liking of the foreign citizen, because you cannot forecast court decisions. Since the national enforcement measures actually boil down to the national instruments and ways and methods. And these have become objective obstacles to unbiased execution and decisions abroad, because they depend to a great extent on the judicial and legal rules and standards in the European Union in particular. And for more than 40 years, the Brussels Convention has existed on the competence of court rulings since 1968, and the transborder implementation of law has somewhat decreased or reduced, although exequatur has been facilitated. And we reversed a number of procedures which were adopted 10 or more years ago. So we made the process easier, you mentioned it. And the list of such measures is being expanded because we are trying in Europe to achieve full implementation of writs of execution in the all-European legal space. There are specific legal documents designed for trans-border circulation, for example, retaining banks' assets. There are regulations to the effect, and this is very important because creditors may get a temporary seizure of property without resorting to the exequatur procedure. And in terms of international legal cooperation, it's rather problematic because you mentioned a number of legal instruments which may facilitate the circulation of writs of execution across the world, but it is true for a number of economic partners which have few numbers, like European Union, for example. But there should be mandatory legal instruments that should provide some alternative decisions, because in international relations, We cannot have short-term harmonization taking into account the principle of territorial sovereignty. We should have new forms of coming closer together based on long-term convergence of the systems, or specific forms of coordination among national procedures. As to convergence of national systems related to the enforcement procedures, we should have better interpenetration, so to say, of the systems and more guidelines to improve the efficiency of execution of court decisions. And we should have projects designed for improved national legislation supported by international financial institutions, which is a major factor for bridging the gap existing between national procedures and systems. And for this, we should have a common legal culture and understanding. So we should contribute to the efforts to improve education, training at the initial and later stages of education, and to have ongoing education and training for the judicial officers in terms of international standards and legal instruments and provisions knowledge. And the Russian Academy, Law Academy, and the Paris Law School have very good relations, and they work in this direction. And there are other ways of addressing it, that is, coordination between the national legal systems. We should know well the differences of ours. We should be very professional in it in order to give good chances for judicial officers. And we should create special instruments for the citizens and companies to recover debts abroad. And we should coordinate our efforts to improve the efficiency of the enforcement procedures. We can achieve this coordination through technical instruments. And it is better to work together collectively. And the contribution by new technologies is a very important factor, the development of communication among the states. And judicial officers adopted this approach within the European Union, and they elaborate projects, international projects, which allow to transfer court on and out of the court acts and decisions, including the Netherlands. The project is called AGS. And it also includes authorization and notification. And the next document will concern international disputes. And they should go through international networks which emerge in Europe and internationally. The National Chamber of ours has a project which is co-financed with the European Union, which is designed to raise the awareness of the citizens about the state of things abroad, and also best practices which may be used in order to create a kind of an information document or information book containing the enforcement procedures existing abroad and the actual facts in order to raise the awareness of the citizens and to create specific instruments designed for serving the citizens of various countries of Europe.
Of course, a less ambitious goal is to have this pragmatic model enabling to use law from those legal acts that favor citizens in various countries and provide governments their impact, influence on processes. And I believe that in the future, the improvement of enforcement proceedings will make it possible to effectively work both their workers and coordinate ministries of justice of different countries. Therefore, such events as today's event will make it possible to move forward and create a basis for cross-border effective enforcement proceedings. Thank you for your attention. I would also like to speak on the first question raised here today. I may not have understood it correctly, but there's this interesting question, or who will pay for the enforcement when the debtor is already in a difficult situation? I could provide this explanation, the way this happens in France, the enforcement of court rulings. The costs are borne by the debtor, and there's a tariff scale, and when there's a claim, recovery, the funds go to the creditor. This is the way it works in the tariff decree. But if the debtor, unless the debtor is solvent, who will reimburse for the cost of the enforcement warrant? So then the creditor bears the costs, which only burdens even more the debt. So this is something we've not yet discussed. There's a chance to debtor in France because the creditor may not advance the money to enforce. There's this jurisdictionary legal mutual assistance. And in the French case, you can have access to this assistance to pay for your legal fees and pay for the costs, the enforcement costs. Another interesting point today was the hierarchy as part of the distribution of funds collected by the creditor in France and Netherlands, the tax debts, there's this, and alimony as well, because my understanding is that when you claim your alimony and go to the enforcement agent, you don't have to advance the money, and the agent will be paid by the debtor as part of direct compensation of the payment. So there's no fee to be paid by the creditor to the enforcement agent as part of the enforcement predomal court or treaty court, arbitration court. And an example that can be given here is the way it works in France. The claim by the debtor against the enforcement procedure. This is done as part of the large instance court, which, well, here the debtor can claim against the timing, for example, to obtain the right funds. So the difficulties arise here when, say, real estate is seized and doesn't belong to him, you can claim against this and go to court. And so these are the considerations I have on various topics. Now I'd like to move to international enforcement, the way we try to do it in France and in Europe to address these issues. And of course, I would be happy to take your questions on the French judicial system. Thank you.
Комментарии у уважаемых участников.
Any more questions from the audience? Is my understanding correct that if it is found out as part of the enforcement proceedings that the debtor is insolvent, then the creditor is in a non-profitable situation? He may not only not receive his money, he will pay for the enforcement proceedings. Is my understanding correct that isn't this a joke on the justice system? It means there's no point in going to court if you know that the debtor may be in liquidation or something like that. Could you please explain on this? Is my understanding correct? Is the creditor supposed to pay for any enforcement proceedings? Thank you. The creditor may indeed, pursuant to a judge ruling, reserve a fund, and when the enforcement is done, he will receive the money back. Only it's the part of the fees that I talked about are in the tariff list of enforcement agents. I can see you're smiling. Why you're smiling? These fees are, well, this is paragraph 10 of this decree. But you have to go to a broader context, because this may look like a caricature as a joke as part of the case discussed by one of the speakers here, when the state has to undertake some of these gaps. But in France, the enforcement agent, well, this goes from the part that relates to enforcement. So you need to think about it in a broader terms than what we talked about. Payment for the enforcement of a court decision. And the enforcement agents, they're part of the National Chamber, and when you had, say, abuse of power, there's insurance paid by the National Chamber. When there's delay in enforcement, when there's impossible enforcement, then there's this insurance paid by them. This is not state insurance. You have to think about this in broader terms. Review the entire system then. Thank you both for the questions and the answers. We will now give the floor for some concluding remarks to the regulators, our colleagues from the Ministry of Justice. We have two ministers of justice on the panel today, and one in the audience, Congolese Republic, Morocco, and Oleg Lezhevsky, Belarus, Minister of Justice, who also was involved in enforcement procedures in his career. Let me give the floor to our first ministers here. Morocco, Minister of Justice, distinguished Mr. Well, the floor is yours. Thank you very much, ladies and gentlemen. I will be brief. As regards the Morocco legal system, it's similar to what exists in France. There are certain differences, of course, but we call them purely Moroccan differences. And I can tell you from the outset that after the presentation of the International Notary Association and the chairman of the preceding Enforcement Association, I can tell you that I am even stronger convinced now that the issues exist and there's this forward movement as well. To compare the systems in more detail, the enforcement in Morocco is a responsibility of the enforcement agents, and we call them so-called court agents. The difficulties we have are our own local difficulties. We have a new Minister of Justice who was appointed 4 months ago. There's quite a few cases backlogged, and this may be a one-off issue, but the problem is for difficult situations with enterprises or issues regarding heritage pensions. And as regards administrative activities, we've recently established this middleman or intermediary institute, which was supposed to address the backlog of cases. This intermediary institute will help, and we're now working on a new legislation. A draft bill was now submitted by the government to help us improve the situation with the backlog. This is an impasse that needs to be overcome, so significant hopes are laid on this. As regards pensions, there's a special government fund, pension cash fund, and if a debtor is unable to satisfy the decision, to comply with the decision, then these funds will be used as an emergency. Just a couple of weeks ago, the king received a high-ranking commission, and by the way, I headed up the commission, chairman there, and we discussed issues related to the operations of many enterprises, because entrepreneurs are supposed to take part in such a dialogue so that the legislation is in the interests of the entire community and the entrepreneurs. And I must tell you that the meeting was a good one. We presented the opinions of our experts, and now we're launching a new system. Of course, it cannot be done overnight, but we need to gain developments, so we contacted our friends, colleagues in Spain and France and other countries. We wanted to summarize the experience and expertise experts from a widest possible range of countries, because I think that will be helpful. Now, as regards the enforcement of our court decisions in other countries and vice versa, we have this measure, and once there's a reconfirmation equator, when it was once it's confirmed or reconfirmed, we do everything possible for the competence of a foreign court to be complied with. We're interested in that ourselves because these are counter processes moving toward each other. So we're looking at it that so that the interests of our population don't suffer. Thank you very much for your attention. Now I'd like to give the floor to the Minister of Justice of the Gay Republic. Thank you very much, distinguished foreign participants. After the Kyrgyz developments of 2010, we've had a referendum and a new constitution was adopted in the Kyrgyz Republic, which dismantled the political system of our country completely. From the presidential republic form of power, we moved to parliamentary form of power. So today, according to the constitution, most of the powers of the president are now powers of the parliament. And now the key issue, the priority, is a reform of the judicial system, establishment of an independent judicial system, moving towards democratization and adoption of democratic values. Now, in Kyrgyz Republic, 70% don't trust the judicial power because all the problems that we have in our country are due to the lack of a fair power system. As regards the judicial reform, according to the Constitution, the Supreme Court and Constitutional Chamber, we now have appointed the relevant officers until they reach a relevant age, regardless of the will of the president or parliament. As regards enforcement of court decisions, this mistrust from the population was one of the reasons, because some of the court rulings are not enforced on time. And as Marta Ortega said, this lack of efficient enforcement, effective enforcement, makes it pointless, the entire system. So there's debate in the parliament underway. We have 4 parliamentary fractions heatedly discussing the enforcement of court solutions, whether they should be under the Supreme Court or the Parliament. Today, the enforcement agents are part of the Judicial Department. The Judicial Department looks after the technical support and maintenance, and the Judicial Department is part of the Judge Council. So Parliament believes, majority of it believes, that it should be part of the it should be responsibility of the executive power, and it should be under the General Prosecutor's Office. Besides, we are now developing at the Ministry of Justice a draft law on the status of enforcement agents, with many issues regarding this topic to strengthen, reinforce their powers and authority. And as regards debtors who are not interested, they sometimes abuse the right, and each time claim against the enforcement agents and court agents. including things like garnishment, arrest of assets, property, and they abuse their right in going to court each time.
And they start new litigation, and thus it's a vicious circle involving courts and so on. We think that the Ukrainian, Russian, and Kazakhstan experience is very valuable, introducing the system of judicial officers or enforcement agents, because they get court support. That's why I think that we should also have the same measure implemented. Besides, we set up a working group or a commission to work on draft law to reform the entire judicial system. Our judges are appointed up to a certain age for a term of 5 years first, then for another 5-year term, and as the rotation and firing those judges who are not appropriate, there'll be a specially set up a council that will engage in selecting judges and assessing their work. We believe that the judicial system should be self-regulating, and it should be governed by a council of judges. Now, President or Parliament cannot exert pressure on the selection of judges. We are making first steps and searching to adopt international and efficient ways and means, and that is why we share your experience, we value your experience, and grateful for sharing it with us. Thank you, Alberto Surganovich. I think that it was really interesting to come to know how the system of judicial enforcement and judicial system are made up in the Kyrgyz Republic. Do you have any comments? So Mr. Lizhevsky, the Belarusian Minister of Justice, he dealt with court enforcement as well. Thank you for giving me the floor. Well, I regret to say that I was absent for part of the meeting, and that is why I cannot comment on the course of the discussion at large. But I'd like to say a few words on what's happening in Belarus in this area. Judicial enforcement is not a novelty for me, because I actually started with this in my career, and I started as a judicial officer and worked for 2 years as an enforcement agent. Certainly there is a problem of enforcement of court decisions, though in the Belarus Republic, the share of enforced decisions is very high, even as compared to the Russian Federation. It amounts to 60 to 70%. When we do recover money based on the claims, though we should aim at higher levels, certainly. In order to achieve it, quite recently, we took certain measures with the SNU, because you know that there are debtors who evade paying their debts. But if a debtor conceals his revenues and has a lot of real estate and property, as often happens, because many of debtors know how to evade law and how to evade seizure of property, and they use their relatives for registering property on them. And with this in view, we introduced certain amendments to the law in Belarus. It makes it possible to take steps based on the court decision if the debtor can afford paying his debts but doesn't want to. So through court, we can restrict their rights or suspend their rights. For example, like going abroad, getting visas, which is a very efficient way of pressure. Because a lot of debtors who had refused to pay their debts at once, all of a sudden, came to us and paid off all the borrowed money. And now we have a new regulation to limit their rights as well. For example, they are deprived of driving licenses for 5 years, but as soon as they pay off their debts, they get the right back. We can also limit the right for hunting, which is quite an expensive hobby, as you know. So if you go hunting and refuse to pay your debts because saying that you cannot afford it, well, that's not appropriate. And the court has the right to limit the rights, well, to use ships and other transportation means. So these are somewhat small hobbies, so to say, which are not inexpensive. And if you refuse to pay your debts, so we'll exert pressure on you through such limitations of your rights. There was an interesting issue raised with proposals to introduce criminal liability for the debtors evading law, but it was not supported by the authorities, and the changes which have taken place are somewhat different. As to the problems faced by the Minister of Justice and the law enforcement service for executing court orders, we don't have a service like in the Russian Federation. We have a different system. The Minister of Justice, that is the executive branch of power, has enforcement agents, and we have a special department dealing with the execution of court decisions, which monitors the work of enforcement agents. And at the same time, judges are involved in this, and they exercise control over the enforcement of the decisions. And this is not an obvious answer to the question whether they should be doing so, because there are pros and cons. The judicial system, on the one hand, should be involved in decision making, in making rulings, and courts should be doing so appropriately. And the judge should understand whether the decision can be executed at all, because they can't make sense if they achieve certain positive outcomes. And we have a somewhat dual service for enforcement. We have general courts and we have economic courts, and quite often the economic procedural legislation and civil legislations regulating general law courts, they do not coordinate their work in terms of priorities of recoveries of debts, so that certain cases which have priorities in general courts are secondary for the economic courts. And thus, enforcement is made problematic, if not impossible at all. And last year, our president issued a decree with a message to courts based on the decisions of the meeting designed to improve the court system. So the priority task for the coming 3 years is creation of a unified service for enforcement agents for economic courts and courts of general jurisdiction. And still, we have an issue which is relevant for us, and we would like to know better the experience of other countries and how efficient and effective the mechanisms in place are. Whether the bailiff service should be unified system which is in no way linked to courts and justice as such, or the judicial branch of power should be closely linked to the service of bailiffs or enforcement agents. Thank you. I think that we have succeeded in discussing a lot of interesting issues in the course of our roundtable discussion, and I hope that enforcement procedure will always focus on the agenda of the Petersburg Legal Forum, because the presentations were extremely interesting and the audience was very attentive and involved. And thank you for your participation and for good contributions made. And I invite you to join us next year as well. Thank you.